Hi, I'm Bob,
And I'm Sherry.
and this is Mostly Politics with Bob and Sherry.
Today we're interviewing attorney David Houck. He's the trial attorney for 20 years and been practicing in Pennsylvania. Welcome.
Thank you. Thank you for having me.
So today we're going to talk about the Supreme Court, the Dobbs versus Jackson, opinion that's been leaked, and track that back, starting with Roe v. Wade and such. But before we do that, I just wanted to kind of talk about briefly what the role of the courts and the Constitution are in the U.S. So the U.S., we have three branches of government. We have the judicial, the executive, and legislative, and two of them are very political. The president, the executive, and Congress is very political, but the courts stand separate. And the reason being is the Constitution and law, we're in a republic where the law is the highest authority. If you go back to the times of kings, the king was the highest authority. He made laws that other people had to abide by, but he didn't necessarily have to follow them. He could do whatever he wants. He was the highest authority. And in a constitutional republic, the law is the high. Nobody, that's when we say nobody is above the law, that's what we mean. So it's really important to understand the law, and that's what the court's role is to help interpret and apply the law in these matters. So, anyway, how's that sound? Could you add to that, David?
Sure. Yeah, when the framers, wrote the Constitution, they wanted to have three co-equal branches of government so that there would be a push and pull between them to control the balance of power. And as you alluded to, under monarchs, you can make any rule you want, but I be king, and that's it. But as a constitutional republic, as we are, or representative republic, the law is the highest arbiter of things in our land, and that's what the Constitution does, and that's what it's for. And the court itself really didn't become the arbiter of the law until a case in 1801 called Marbury v. Madison, and that was a dispute over a commission of appointing a judge that Thomas Jefferson wanted. It was a fight with the Federalists, and Chief Justice Marshall actually took the opportunity in that case to write an opinion that essentially said that of the three branches of government, the courts are essentially the most equal because they get to be the arbiters of what the Constitution says and how it will be applied. And until that case, the court's role was sort of undefined. Its jurisdiction wasn't really defined, and its ability to interpret the law wasn't clear. But with that case, it became clear.
Okay, very good. So this is really a kind of discussion of like sort of technical, the law. We're not getting into the morality of abortion or, right, wrong, the morality of choice or anything like that. We just want to get into, the law. And
yeah, so in the case of Roe versus Wade, can you explain in a simple term, what does it say about the rights of a woman and what does it say about the rights of an unborn?
Well, that's a great question. Roe is, it's an interesting case in terms of its opinion. It doesn't really say much about those things in reality. Roe's decision is based on the right to privacy. From the right of privacy, they then say you have the right to end fetal life. The decision itself was not really founded in the Constitution at all. And that criticism of Roe isn't my own. Even after that decision, legal scholars, even who supported the decision, were saying that it was very wrongly decided. When the court makes a decision, it's supposed to take the issue at hand and apply it to the Constitution and decide whether or not it stands scrutiny or passes muster. And the court never really did that in Roe. It looked at a bunch of outside factors, but it never really gave a constitutional basis for the ruling. And the right to privacy, as we understand it, falls under the 14th Amendment, which has to do with procedural due process, which are the rights that aren't expressed in the Constitution directly. like we all know, amendments 1 through 8 cover, free expression, free association, free speech, the right not to self-incriminate, illegal search and seizure, the right to counsel. All those rights are covered under amendments 1 through 8 of the Bill of Rights. And those are called procedural due process. The substantive due process rights are rights that might not be articulated, but we all understand are part of the history and tradition of our country. Okay, so for something to qualify as a right under the 14th Amendment and substantive due process, that's where you would find it. And so when they were deciding Roe, the court needed to find in our traditions and in our history and in our common law evidence that abortion was a right. They didn't do that. They literally couldn't do that because if you really look at the common law of America up until the time of Roe, we had 185 years of law that found abortion in many instances to be a crime. Not always, but in many instances it was. So it was not a part of our tradition and history, and so it was not to be found as an implied right. But the court was driven by a result-oriented outcome, which means it's almost like in research, you have to find a result. But in this instance, you already know the result, so you go and find what you want in the data to say this equals our result. And that's essentially what happened with Roe. And the court, I think, believed that it was going to end the controversy about abortion, but instead it ignited the controversy that we have today.
Well, as a person who worked in science and used a scientific method, what you just described would be bad science.
And it's bad law.
Okay. Well, so
wait, I have a
ahead.
question. So, what was the ultimate decision with Roe versus Wade? Basically, just saying abortion is legal.
Well, what they said was that the right to privacy is part of the 14th Amendment, and there's two types of privacy that the 14th Amendment sort of recognizes. One is the right to keep your documents that are about you are private, and you can protect those things. You have a right to privacy to those things. The other part, or the second kind of privacy, is to be free from government interference about very personal decisions. Okay, and they used that and attached it to the right to have an abortion. But the reason that is different, though, is they conflate the idea because it's not a right to privacy to be able to end fetal life, which is what abortion is, right? And that's where the controversy sort of erupted, because ending fetal life is not the same thing as a right to privacy, and it was on that the whole issue sort of turned.
The way I understand Roe v. Wade, the court developed this trimester thing. So generally, they were saying in the first trimester, the states cannot restrict abortion in any way. It's a full right to privacy choice thing on the mother. And I think in the second, there was some ability. But in the third, they just kind of left it open. They said that there is rights to the unborn in the third trimester, and they would allow the states to decide how much and to what extent they want to protect those rights. Is that accurate?
Yeah, that's accurate, Bob. And the way the court did it when they wrote the opinion in Roe, if you read that opinion, it actually reads like a piece of legislation, and it articulates these trimesters, and it says that viability is the basis upon which this is going to apply, and at 28 weeks. That's the definition of viability outside the womb. Of course, the problem with that definition is that as prenatal medicine advances, the window for viability gets a lot wider. And so it was 28 weeks in 1973. Now it's down to 20 weeks. I think we're in that ballpark. So how can that rule even apply anymore? So it was a nebulous rule. And in fact, I guess we'll talk about it in a minute, the Casey decision actually pitched that completely. and got rid of that and created an even more nebulous test, if you could believe it.
So in this case, so I'm a little confused. I mean, you have to excuse me because I'm not from this country. So essentially, it was an opinion from the Supreme Court, right? But when an opinion is written, does that mean it's an actual law?
It's an interpretation of the law. So
Okay.
a case came up before the Supreme Court on the issue of abortion. There was a law that was restricting the plaintiff from being able to have an abortion. And so this came up before the court. And at the time, there were 30 states that had laws on the books about abortion. And with the Roe decision, by judicial fiat and the stroke of the pen, the court struck down all abortion laws in the United States and said, that you couldn't restrict abortion. And it really took the issue away from the people. And there's a lot to talk about when you're on these types of questions, these sort of empirical rights or these substantive rights. When you're talking about a procedural right, it's something that we all understand, and we can look at and compare to the Constitution. When you're talking about these empirical rights, they can be very emotional sort of issues, and courts aren't really supposed to decide emotional issues. Their job is to interpret the law. And when an issue like this comes up, it's for the people to decide. It's for the legislature, as the representatives of the people, to decide these issues. And that's where it was when Roe actually came up. But because there was so much controversy with the abortion question, the court thought it could settle the issue, and it didn't.
So in essence, the Constitution protects certain rights of the people. So it says, government, you're not allowed to create any laws or take any action that takes away these rights or infringes too much on these rights. So in this case, what they were basically ruling against were laws that restricted this perceived right of the woman to privacy. So they weren't
Correct.
actually they weren't saying abortion is legal, not legal. They were just saying that states cannot make laws that restrict this right to privacy, but it only applies up to the point of viability.
That's exactly right. That's exactly.
Nope.
And of course,
So go ahead.
no, I was just going to say that just caused the controversy. 20 years later, in the KCB Planned Parenthood case, the court revisited this question. But yeah, Bob, that's essentially what happened.
Just for my one thing that confuses me about that is, so in essence, the court was saying that in the third trimester that this is a person, it's a life, because that's the only way they could justify allowing the states to infringe on what they said were the privacy rights of the woman. So now suddenly another person is involved. It's another human being. So why would they rule to protect the mother's right to privacy, but in the process affirming that this is a person, and yet just kind of leave it wide open to say, you might want to protect it, you don't have to?
Well, that turned on the issue of viability, right? Once the baby was viable outside the womb, it's a person and
Okay.
It should be protected. So once you pass that 28-week threshold in the Roe case, the baby's now viable outside the womb, so you have to protect that life. And that's what it did. And interestingly, a lot of Western countries, Western European countries, have abortion laws that are far more restrictive than our own. It's remarkable that Roe, instead of settling this issue, really took it away from the people and said, this is how we're going to do it. And it really caused a huge problem.
Because my mother had 3 abortions out of necessity. That's before they restricted you can just have one child. My sister was born in 1978, and right after that, the government said you can only have one child. So essentially what they did is the government forced a lot of people to have an abortion. And if you decide to have a second child, you get penalized for having a second child. But now with the society that needing more female, because there's a lot of boys, not enough women, they give up the girls for adoption. So the family can have a second child, to fight for a boy. Now they went from you allowed to have 2 kids. Now the Chinese government say now have 3 kids. But, nobody can afford it. But that's another issue. That's a whole different issue. So can you help us summarize about what?
Oh, I was going to say, why don't we ask about Casey? We've alluded to it a couple of times.
Okay. Well, do you want to talk about the case with the Planned Parenthood versus Casey and how to change
Sure.
the court's approach to abortion?
Sure. Casey popped up 20 years later, and it was a chance for the court to revisit Roe and try to maybe fix all the problems that Roe sort of created constitutionally for the court. And it's an interesting opinion, and if you're interested in these type of legal issues, I recommend actually reading Roe and Casey, those opinions. But Casey essentially overturns most of Roe, and it ejects the trimester framework that applied. And what it does do is it says we're going to retain the central holding of Roe, which is the viability measurement. And now it's going to say that you can't have an undue burden on abortion. And it's even a more nebulous test, because when you talk about a due or undue burden, how is that defined? What parameters do you use to define that? Every judge will have a different opinion then about what is a due or undue burden. So Casey, instead of sort of fixing the problem, exacerbated it. And they also felt when they wrote that opinion that it was the final say on the issue. They fixed the problem with Roe. This is the new thing. We've settled the issue. Let's move on. Nothing to see here. But again, Casey, as we all know, did not resolve the abortion question, and these problems and these fights have persisted.
So is Casey still based on the perceived privacy right?
Yeah.
Okay.
Yeah, it's still it's the central holding is still there.
That's the central holding.
And it relies on all that. Yeah, but instead of fixing everything, it really just exacerbated.
Right.
Now, what year was Roe versus Wade? You have to excuse me. What year was Roe
That's
versus
okay.
Wade?
That was 1973.
And then what year was, so 1993 is Casey. Okay. Now I have a
Right.
question. So in 1973, that's, the baby boomer age, the culture America at the time was, sex, drugs, and rock and roll. And a lot of people probably wasn't paying too much attention. There's probably a lot of women at the time that, not careful, or the culture was promoting sex at the time, probably need an abortion. Do you think the culture at the time that had something to do with the opinion of the Supreme Court? And was the Supreme Court a lot of liberal judges at the time or more conservative judges?
Well, those are really good questions, Sherry. So I think culturally at the time, America was certainly in a different place with the Vietnam War and sort of the Cultural Revolution and love the one you're with and all those sort of things happening in our culture. Certainly they had an influence across the spectrum, not just on the legislation and the presidency, but certainly on the courts, because the courts are made up of people. And certainly the judges that sit on those courts may try to be as objective as possible, but certainly they have opinions too. And some of them allow those opinions to filter into their views. So yeah, I think that those things all had an influence back then, and I think also that the Supreme Court at the time, I think it had a majority of more liberal, if you will, judges at the time. Roe was a interesting decision in that they really thought they were solving a cultural problem. And in Casey, you had a plurality in the court. It was a 5-4 decision in Casey, where two of the judges wanted to overturn Roe outright. I think 3 wanted to support it, and there were 4, or maybe I'm having that backwards, who wanted to hold on to the central holding, if you will, but get rid of a lot of the reasoning that Roe used. So when you look at the 1973 court, yeah, I think that those things mattered to the court back there. And I think, again, like I said at the beginning, it was sort of a results-oriented outcome that they were looking for.
Dave, can you tell us exactly why is there a case? What is the case with Parenthood versus Casey? What was that case all about?
Sure. That case in 93 had to do with a wife that wanted to have an abortion without telling her husband. And again, it was a right to privacy issue, right?
Okay.
And that's what brought it up to the court. And that's when this court in the plurality sat down and came up with their decision in that case.
Okay, sure. So the basis was still privacy. She was just trying to make the claim, well, I'm the woman, even though he's my husband, I shouldn't have to tell him. So really trying
Correct.
to solidify that right to privacy.
Right.
And do you think they did that? I mean, did they rule that she did have the right to keep it private from her husband?
They did.
Okay.
They did. They said that she had the right to do that. Well, she had the right to privacy,
Right.
and that the courts could not restrict her right to the abortion.
Okay.
Well, then once she sued, I guess the husband found out.
Yeah.
Yes.
Can you summarize for us where we are right now, federal law versus state law? Like, where is Pennsylvania at when it comes to abortion?
Well, again, we're all basically under the federal rules as it relates to abortion. Now, there are states that are passing laws right now that are restricting abortions. I think right now there's 26 states. Pennsylvania is not one of them that restricts abortion or outlaws it in many cases. And these states have all sided with Dobbs and are asking the court to overturn Roe and Casey and get rid of that law altogether. So that's kind of where we are, and that's why the Dobbs opinion and its leak is so big, and why people are so upset about it.
Who is Dobbs and what's their backstory?
Well, the Dobbs controversy, I have to be honest, I'm not sure the facts completely in that case.
Okay.
I know it had to do with 15 weeks. I think there was something about it was restricting abortions at 15 weeks, I think, which is below the viability measurement. And that was the challenge, that you couldn't, have this undue burden on an abortion that was under the viability of 20 weeks. I think it's at 15 weeks. And I might have that off a little bit, but I think those are the central facts of the case, and that's why it went up. These abortion cases have been brewing for quite a long time, and this is the first one with the new court to actually be granted certiorari, which means the court has agreed to hear it and make a decision.
So with Casey and with Dobbs, these are people seeking to strengthen, their right to an abortion. But what ends up happening is they force the court to go back and look at the prior rulings, and in essence, they end up weakening it.
Well, maybe, Bob.
Okay.
Right? It depends. It depends on how the court will rule, right? And we don't know how the court's going to rule. And if the court is doing its job, it's going to rule based on the laws and the histories and the tradition of our country and the Constitution. So when they get things wrong, and the court has got things wrong many times before, Plessy v. Ferguson being one of the most famous, cases that they got wrong, that got reversed by Brown v. Board of Education, right? So before there was separate but equal, but that was wrong under the Constitution, and Brown v. Board of Education set that right. And there's just a large body of of Supreme Court case law that supports that sort of straightening the ship when the court gets things wrong as it relates to the Constitution. It has to be fixed, and the boat has to be straight, and that's really the court's job. And I think if you read the Dobbs opinion, that's what they're trying to do.
So this leaked opinion is just one of the justices? Is that something they write for each other? I mean, what was actually leaked?
Well, that's a great question. The opinion itself is written by Judge Alito, but it's written for a majority of the court, right? So the judges are free to concur with an opinion. They can dissent from an opinion. They can do both. They can concur with parts of it, dissent with other parts. But in this instance, Justice Alito is writing an opinion for the majority of the court who want to overturn Roe v. Wade and essentially return the issue to the people. That's all they're really doing. They are not banning abortion in America. If the Dobbs opinion turns out to be the new law, it doesn't ban abortion. All it does is turn the issue over to the states and to the people where it belongs, so that they can decide what laws they want about abortion and how they want to control it.
Okay, so
and that's where it should be.
As a majority opinion, that just means they've spoken, they've discussed it, and he took it. He was sort of the scribe to say, okay, I'll put this in writing, what we all discussed, and sort of what our consensus is.
Exactly.
Okay.
That's exactly right.
Okay.
And I think anybody that has a real interest in this issue and cares about it, and many people do, you should read the leaked opinion because I think it's not a political treatise if you read it. It's a historical analysis of the Constitution, of Roe and its decision. It talks about Casey, and it just says, look, we have to fix this. This problem this is a problem with the Constitution, and we have to fix it. This issue shouldn't be decided by 9 judges. It should be decided by the people and their representatives, and that's where this issue belongs.
Well, as an attorney, and you certainly know a lot about the law and what this opinion is all about, does it frustrate you oftentimes, especially in a big election year, people politicize these issues and causing a big stir versus just cooler head prevail? Let's really see exactly what's happening here.
Yeah, I mean, it's the polemic of our society, right? To take these issues like abortion and others and just turn them into talking points. This is an important issue for both sides of the question, and I think that there are good arguments for and against on both sides, and I think that it is an issue that the people need to decide. But you can see why politically people would glom onto these things and try to use them, because you're going to get votes one way or the other. So you can see why certain issues do get politicized, for sure.
So activists will use them, politicians will use them, but if we describe, and just take my definition for the sake of discussion, that a pro-choice person says that it's a moral imperative, morally good, that a woman has full discretion, over abortion throughout the term of pregnancy. Let's just say that's a pro-choice. And a pro-life person would say that there's a moral imperative that that's a living person and there should not be any abortion. Okay. So should it matter if your court is made up of people that are on one side or the other? I mean, if they were congressmen, obviously, and then they vote, how it's going to go. If you have a majority of pro-life people, you're going to get pro-life result. If you get a majority of but in the courts, shouldn't they be ruling based on law and, those issues? And really, whether they think abortion is a moral right or wrong, should that even matter?
No, it shouldn't, Bob. The question should be, how does the law apply here? The courts are supposed to be objective and apply the law. And that's why I think reading the Dobbs opinion is so important right now, even though it's not law. But I mean, it's you should read it just for its history and analysis of Roe and how and why that opinion is considered so poor constitutionally constitutionally speaking. It's not a good opinion, and that's exactly what they didn't do in Roe. They didn't look at history. They didn't look at the common law, and they didn't look at the Constitution. They wanted a particular outcome. So what they did look at, what they did talk about, wasn't really relevant to the law and to the Constitution. And that is what they're supposed to do. And when you're at the trial court level, you're more apt to run into judges that are less objective. Just because there's more judges, there are more of them. But when you start to move to the appellate level and then the Supreme Court level, even at our state Supreme Court, you hope to have judges that are sitting in those seats because they're more objective and they care and want to follow the law. And as a trial attorney and as an advocate, I certainly go in with my opinion about the law and what I want the court to say and how I want the court to rule. And I will advocate zealously for my view. But if I don't prevail, I have to accept what the court says.
In your 20 years of being a trial attorney, have you ever represented cases as abortion cases?
I've never had an abortion case. I have had some Title IX and Title VII cases, which is excessive force and employment cases and stuff like that. And I've argued in federal court in those cases. But no, I've never had an abortion case or had an occasion to be on.
Okay. You mentioned Title IX. Is that the female sports? Is that related to female sports?
Well, Title IX more like those are more like employment issues, discrimination, gender, race, sex, that sort of thing. And then Title VII, I've had cases that deal with excessive force and the use of force by police and the constitutional application of those questions.
One of the reasons we wanted to do this interview is I feel like, to that point about it really shouldn't matter, the political leanings of the justices. Obviously, nobody's completely, objective. We're all biased. But if they're committed to the law and their jobs and their roles, then they should actively, try to sort of suppress that and only base their opinion. And that's why there's 9 of them and they challenge one another. But I just felt like, in the media, when I watch the reporting on this, it's always, appointed by this person, conservative justices. I mean, I don't think I ever hear them say liberal justice. It's always there's conservatives and they're appointed by this. And it almost feels like they're kind of inflaming, a problem. Like, I don't think that people should be outside the homes of justices. I mean, it's if you want to be there and hold a sign and just have a peaceful demonstration, but when you're, angry and yelling and harassing, you're trying to influence the court. I think that's inappropriate, and I don't see the media really reporting it that way.
Well, Bob, there's actually a 1950 law that makes it a crime, actually, to protest outside judges' homes. Because you don't want your judges to be subject to influences from the culture, right? Because what the culture thinks isn't what a judge is ruling on. The judge is ruling on the law and how that's going to apply. And I think I sort of alluded to that in the beginning when we were talking about sort of these empirical rights, when you're talking about the psyche of the culture of the society at a particular time, like in the 70s. You really don't want your judges to be subject to those pressures when they're making a decision. And so you shouldn't be outside a justice's house actively protesting and demanding a certain result. That's wrong. The right to protest in this country is an absolute right, and people have that right, and you should do it. But there are ways to do it, and if you want to protest the law, you should be protesting your legislatures down there in front of the Congress and protesting and calling your representatives and saying, "This is the issue, man. You got to change it. You got to do what I want." And you can have all the protests you want in that regard, march all day, and that's all good. But the court is not to be subject to those sorts of influences, because you could imagine, the democracy itself. There's a distinction, right, between democracy and a representative republic. And democracies inevitably eat themselves, and that would be an example of it. The way I like to describe the difference between a representative republic and a democracy is if you have a guy commits a crime, runs out of town, and a posse goes after him, and these 15 guys on the posse capture him, they vote right then and there. Do we hang him? Yep, gone. That's a democracy. Now, a representative republic, same facts. When they say, what are we going to do? We're going to hang him. They say, no, we're going to take him back into town. He's going to have a trial. He's going to get due process. He's going to have a jury of his peers, and we're going to let them decide. That's the biggest difference between a democracy and a representative republic. And sort of the things that we're talking about here, this influencing the courts, that's how a democracy will eat itself.
Nobody likes the law when it goes against their agenda. Everybody likes the law when it affirms their agenda. So, just remember, I mean, that's the stability to me. So, if you want to ignore the law and subvert the courts and everything, in this case of abortion, there's going to be another case down the road that you're not going to want that to happen. I mean, I've been hearing for decades from the pro-life or pro-choice side that the Supreme Court has spoken. So they cite the Supreme Court. This is the law. We have to obey the law. They affirm the law. Now they're the ones trying to undermine the law. The process, if you will, the process of interpreting and applying the law. So that's how it goes. And the funny thing about the courts is that if they're doing their job, especially the Supreme Court, if it's doing its job, you ought to be able to open up that opinion and read it and understand clearly how they got to their conclusion, because they lay it out. Right.
And the Constitution is the bedrock that has to survive the ages, right? It's the thing. We have to adhere to it and be true to the Constitution. And if we go too far away from it, we'll lose everything. So that's why it's such an important document. And that's why it's so important that the courts, follow that Constitution and do a good job when they do that. And they don't always, but they can if they look at history and the documents. They can do the right thing.
So basically, what you're saying is, this legal opinion, it's actually giving the power back to the people to make decisions on, this whole abortion issue. Where can people read this an opinion?
You can probably just Google it and find it in less than a minute.
Okay.
It's widely available. It's out there. And Sherry, to that point, real quick, I mean, with the Dobbs, let's assume the Dobbs decision comes out the way it's written. California has already declared it's going to be an abortion sanctuary, where you can get an abortion all the way up until the time the baby's born.
Right.
I mean, literally. And that's going to be their law. And so Dobbs isn't going to end that. All Dobbs is doing is giving it back to the people and saying, this is not a constitutional issue. This has nothing to do with privacy. This has to do with ending fetal life. And you guys figure it out for yourselves. You tell.
And to that point, so there may be some southern states that, completely ban abortion. And I know that one of the counters is, well, that's unfair to the poor people that can't afford to go to California. But there's a lot of money on the, pro-choice side. They could easily funnel that money towards, a service where they help people, transport them, take them to places where they can get abortions. I mean,
and
right.
they're already talking about that.
Pardon?
Yeah, they're already talking about that. Yeah, they're already talking about that and making those types of services available.
Yeah.
So, I mean, it's a very emotional issue. It's a moral issue. It's been a question of our age, really, this modern age. And unfortunately, because of Roe and because of Casey, it has really involved the court and tied the court up in an issue where it really didn't belong.
And that's really a testament to the freedoms in the Constitution that our whole country's built on. Yeah, so one state can ban it, one state can make it free. The people are free to deal with that however they want. There's nothing stopping someone, Texas cannot stop their residents from leaving Texas and going to California to get an abortion. I mean, there are other places where that could happen. I mean, even, in China, people can't just freely move about and do things like that if the government doesn't want them to do it. So.
Right, and that's the freedom of movement. There's another 14th Amendment due process sort of right? It's not articulated in the Constitution, but certainly everybody believes you have the freedom of movement.
Mm-hmm.
And that's deeply rooted in our histories and in our traditions as a country. So it's a right, and it's protected. So it is important that the court, sort of get this issue out of it and back to the people where it belongs. And the people can freely decide then what they want to do.
So, Dave, we're going to end this interview. Thank you so much for coming on. And if people want to reach out to you, what do you specialize as far as trial concerned? How do you have a website, and how can people reach out?
Sure. I'm a trial attorney in Pittsburgh, which means I represent individuals who've been injured, whether that's from accidents or whether that's from work or defamation, by products, anything like that. So that's the type of work I do. I try cases in that respect. And you can reach me at the law firm of Ogg, Murphy, and Perkosky, PC. And phone number there is 412-471-8500. Or you can email me at dhouck@allinfirm.com.
All right. Well, thank you so much to come on Sunday.
Well, thank you.
David.
It was a lot of fun.
Okay.
Thank you so much.
Have a good one.